Hello everyone, welcome to Readers IS. Today we'll be dealing with Chapter 2 of NCERT Class 11 Political Science Indian Constitution at Work. Earlier we have dealt with Chapter 1 and we have seen in the previous chapter that why a country needs constitution and how the constitution becomes effective. Now in this chapter we'll read about the rights. These rights have restrictions on the government. These rights will act as limitations on the powers of government. This we have seen in the previous chapter. So this is chapter number 2 of 11th standard NCERT Constitution at Work. Rights mentioned in the Constitution of India. So we'll in brief see rights. So in this chapter we'll deal with three aspects. First is fundamental rights. Second is DPSP, Directive Principles of State Policy, and third is the fundamental duties. So we'll deal with this all three aspects in this chapter in the following manner. So after studying this chapter, what a student will able to answer? What are the different types of fundamental rights listed in the Constitution of India? These rights are protected. In what manner they are protected? And in protecting these rights, what is the role of judiciary? Finally, we will see the difference between fundamental rights and directive principles of state policy. We will see in detail whether fundamental rights are enforceable, DPSP are not enforceable. So, 1, 2, 3, 4. These four aspects will be covered in this chapter in this manner. And with this agenda, we shall begin our class. So, before understanding rights, we should understand the importance of the rights with these two case studies. This is case study 1 and another case study is related to Machal Lalu. So, in case study 1, this case study is of 1982 based on fact. In this case study, we will see that construction work was going on during the ancient games. And in this construction work, the government had hired few contractors. These contractors had hired construction workers, but these construction workers were living in a very poor conditions. And these construction workers were engaged in building flyovers and stadiums all over the Delhi. These workers but were put in the very poor conditions. They were paid less than what they deserved. Even they were paid less than the minimum wages which were decided by government. So, in this situation, what do you think? Which kind of fundamental right is violated? Do any of you have any kind of idea that construction workers are the citizens of India? Since they are citizens of India, they enjoy certain fundamental rights. So, there are many types of fundamental rights. So, which kind of fundamental right is violated in this case? So, in this situation, a team of social scientists studied the poor condition and they petitioned in the Supreme Court. And this social scientist argued that employing a person to work less than the minimum prescribed wages will amount to begar and forced labor. Now, ahead you will see that begar and forced labor are prohibited under Article 23 of the Constitution. So, since this form of begar or forced labor, in other words, if minimum wages of a country are rupees, for example, 100 per day, and if this employees or the construction workers are paid rupees 80 per day, so this is the minimum wage. And if there is any payment below the minimum wage, this will be considered as begar or forced labor and Constitution prohibits begar or forced labor under Article 23. So this kind of forced labor or begar is a violation of fundamental right against exploitation. So in this condition, since it violated fundamental rights, court accepted the plea of the social scientist and directed the government to ensure that the thousands of workers will get the prescribed wages for their work. So what do you think from this case study? If there would have been no fundamental rights, what would have been the condition of these construction workers? So, do you think fundamental rights enable people to live life of a dignity? This is the utility of fundamental right. And in case of absence of fundamental right, these construction workers would have continued to work and they would have received payment below the minimum wage and their exploitation would have been continued. It is for this reason fundamental rights are important not only for India but any society of the world. Now we'll see the another case study of Machal Lalung. This person, Machal Lalung, he was of the age of 23 when he was arrested. He belonged to Assam, Chuburi village of Moregaon district of Assam, and he was arrested on what charges? Of causing grievous injuries to some other person. Later it was found that he was mentally unstable to stand a trial. So he was sent as an under trial to Lokpriya Gandhi Gopinath Bordolai Mental Hospital in Tejpur for the treatment. Later he was treated successfully, and after completion of his treatment, when he was mentally stable to go under the trial, doctors wrote a letter to the jail authorities in 1967 and 96 that is he is fit to stand trial and he should be his trial should be continued further for the crime perpetrated by him. But none of the jail authorities or police responded or did not pay any attention. It is because of this reason Malchal Lalung remained in the judicial custody, even though he was mentally stable after the treatment. Later, in July 2005, he was released. And when this person was released, he was age of 77. So when he was arrested, he was 23, and when he was released, he was 77. So you will see that for 54 years of life he spent into custody for just a minor crime of causing grievous injury. In this case, that he spent 54 years in jails in the custody, his case never came up for the trial. Finally, he was freed when National Human Rights Commission intervened after it was doing regular inspection of the under trials in the state. So Machal's whole entire life was wasted because he didn't get an opportunity of the proper trial. What do you think? What kind of fundamental right was violated in case of Machal Lalang of Assam for spending 54 years in jail? Do you think Indian Constitution provides the right to life and liberty? This right is a fundamental right. Right to life and personal liberty under Article 21. This fundamental right of Machal Lalung was violated when he spent 54 years. So, just think, if there is no fundamental right, what would have happened to Machal Lalung? And if there would have been no fundamental right to life and liberty, what would have happened to other many people like you and me? So, right to life and liberty means or includes that every citizen will have right to fair and speedy trial. So, when right to life and personal liberty is interpreted broadly, this kind of right is a derivative right. Right to life and personal liberty is mentioned in Constitution. This is derived from that right. So this is derived right. When you interpret broadly right to life and personal liberty, you get right to fair and speedy trial. This right of Malchal Lalung was violated. And this case of Machal's case shows what happens when rights granted by the Constitution are not available in practice. They are available in theory, but they cannot be enforced in practice. Now just think, What if Machal was a rich and powerful man? He could have hired lawyers and his right would not have been violated. Just think, what if those construction workers were engineers instead of simple laborers? Would these engineers would have been forced to do begar? Would their rights would have been violated? So in this case there would not have been violation of rights. So from above two case studies, what we can conclude is the significance of fundamental rights in our Constitution of India. And just now you can imagine the absence of fundamental rights in Constitution of India, what would have happened in above two cases. With this small story, now we'll begin with fundamental rights. So I'll explain again in brief that in the first instance of construction workers, there was violation of rights. It was challenged in court. Rightful wages they should have been received, and constitutional guarantees, right against exploitation. So this is in brief of the first case study. Now we'll see the Bill of Rights. In other words, fundamental rights. So both these above examples show that the importance having rights and actual implementation of rights is important for an individual to live a dignified life. Democracy must ensure that individuals have certain rights, that the government will always recognize these rights. Therefore, in practice, most of the countries list these rights directly in the constitution. Such kind of list of rights which are mentioned directly in the constitution and mentioned and protected in the constitution is called Bill of Rights. So you have many rights, legal rights, constitutional rights. So rights which are directly mentioned in the constitution and protected by the constitution are called Bill of Rights. This Bill of Rights prohibits government from acting against the rights of the individuals and ensure the remedy in case of violation. So what do you think? These rights given to individual, whom does constitution protect? These rights of individual. The rights of the person may be threatened by another person or private organization. In such a situation, individual would need the protection of government, so it is necessary that the government is bound to protect the rights of individual. But on the other hand, there are three organs of the government. These organs can also violate the rights of other person. Okay, so violation of rights can be by some other person, can be by a private individual, or by the government itself. So in case of violation of rights by the government, we'll see ahead what happens. So you can here see there is Bill of Rights, means a list of rights mentioned directly in the constitution and protected by the constitution is like a warranty card when you purchase a TV or fan. What do you think? Now, in context of India, we'll study the fundamental rights. During Indian national movement, the freedom or the nationalist leaders has realized the importance of the rights and demanded this British ruler should respect the rights of the people. It is for this reason the Motilal Nehru Committee demanded a Bill of Rights as far as back in 1928. Therefore, it was natural when India became independent and constitution was being prepared, and when constitution was being prepared, there was complete consensus among the founding fathers to include Bill of Rights in the constitution. Okay, so there were no two opinions regarding the inclusion of protection of rights in the constitution. This list of rights in the Constitution of India, which are protected by the constitution itself, it is called fundamental rights. So this is the meaning of fundamental rights. What do you mean by fundamental rights? A list of rights mentioned in Part 3 of the Constitution of India, guaranteed by the Constitution of India. Such list of rights in the Constitution of India are called as fundamental rights. So, what do you mean by the word fundamental? What do you mean by the word fundamental when I use the term fundamental rights? Here, the word fundamental suggests that these rights are so important that the Constitution has listed them separately. These rights has been listed separately and special provisions are there for the protection. These rights are listed specially in Part 3 of the Constitution of India. We'll see ahead. And fundamental rights are so important that Constitution itself ensures that it will not be violated by the government. Now we'll see fundamental rights are different from the other rights. How fundamental rights are different from the other legal rights. Other legal rights. So, ordinary legal rights, they are protected and enforced by the ordinary law. But fundamental rights are protected and guaranteed by the Constitution of India. So, this is the difference between ordinary rights and fundamental rights. Fundamental rights are protected and guaranteed by Constitution, while ordinary legal rights are guaranteed or protected by the ordinary law, which is subordinate to Constitution. Then another difference, you will see that this ordinary rights can be changed by the legislature by ordinary process of lawmaking, but fundamental rights can only be changed by amending the Constitution and not by the ordinary law. Apart from that, you will also find that no organ of the government can act in a manner to violate this right. So this will study in this chapter of judiciary later, how judiciary will protect the fundamental right. So here we have seen the difference between ordinary rights, why these are called ordinary rights, and constitutional rights, or in other case fundamental rights. So if you will trace the origin of the ordinary rights, it's ordinary law, while fundamental rights origin directly from the Constitution. If you have to create ordinary rights, you have to pass a new law. But if you want to create new fundamental rights, you have to amend the Constitution. So this is the difference between ordinary right and fundamental right. Now you will see a case study of South Africa. As in case of India, South Africa has also certain fundamental rights in the Constitution called as Bill of Rights. So this Constitution of South Africa was inaugurated in 1996. It has a list of rights in the Constitution which is called Bill of Rights. So some of these rights which are important in South African Constitution is right to dignity, right to privacy, then children's rights are also mentioned directly in the Constitution. Right to information, which we created, Right to Information Act, is directly in the Constitution of the South Africa. So these are the rights which should have been in the Constitution of India also, but it is not. So this can be one of the criticism of the Constitution of India, that right to information is not a fundamental right as it is in the Constitution of South Africa. Now, after seeing different kinds of rights, we'll see types of rights. Before moving towards types of right, we will see that in case of violation of fundamental rights by executive and legislative action, it is declared null and void by judiciary. If the legislative or executive actions violate any kind of fundamental right, the judiciary can declare such actions null and void. But you have to keep in mind that fundamental rights are not absolute or unlimited, because government can impose reasonable restrictions in case of fundamental rights. For example, freedom of speech and expression does not include hate speech, because hate speech is generally used by the politicians during elections to create a communal divide and win election. So freedom of speech and expression does not include hate speech. So this kind of reasonable restrictions can be imposed by the government. And since this kind of reasonable restrictions can be imposed on the fundamental rights are not absolute or unlimited. This should be kept in mind. After having seen all these things, now we'll see the types of rights. There are different types of fundamental rights. Out of all this right, first right is the right to equality. Right to equality. This right to equality is included from article number 14 to 18. So article 14, 15, 16, 17 and 18, these are collectively called right to equality. In this right, we will see how right to equality is there. Now, the Constitution of India in Part 3 has all this kind of rights. So how many types are there? Total 7. That is, right to property is there, but it is now deleted. So at present total we have 6 fundamental rights, and all these fundamental rights are in Part 3 of the Constitution. We'll quickly see the different types of fundamental rights. First, we'll see the first type of fundamental right, that is right to equality. Right to equality is from Article 14 to 18. In this, Article 14 includes equality before law and equal protection of law. So, Article 14 includes equality before law and equal protection of law. Then there is Article 15, which prohibits discrimination on the grounds of race, religion, caste, sex, place of birth. Here you can use R, R, C, S, P. Religion, race, caste, sex, place of birth. Article 15 prohibits discrimination on the grounds of R, R, C, S, P. Okay. Then you will see Article 16, which provides equality of opportunity in public employment. Then Article 17 abolishes untouchability. Article 18 abolishes titles. So these are the different kinds of fundamental rights under the right to equality. Now we'll see right to freedom from article number 22 to 26. Article 19 includes following rights: in protection of right to freedom of speech and expression and assemble peacefully, form association, move freely throughout the territory of India, reside and settle in any part of India, practice any profession. These all are the rights under Article 19. You will find that one more fundamental right has been included under 19 recently, is right to form cooperatives. This we will deal in detail in our regular classes. Then you will see another fundamental right, that is protection in respect of conviction of offenses. Protection in respect of conviction of offenses. This right is under Article 20. Then you have Article 21, which gives right to life and personal liberty. Then there is Article 21 capital A, which provides right to education. Then there is Article 22, which provides protection against arrest and detention in certain cases. So Article 19, Article 20, 21, 21A and 22. These all are included in right to freedom. This is after right to equality. Now, after Article 22, there are two rights. Right against exploitation, that is Article number 23 and Article number 24. Article number 23 is related to prohibition of traffic in human beings and forced labor. Prohibition of traffic in human beings and forced labor. Article number 24 deals with prohibition of child labor in hazardous jobs. Here the age of child is below the 14 years. Here the age of child is below 14 years. After this right of exploitation, we will see right to freedom of religion. Here article number 25 is related to freedom of conscience, free profession, practice, propagation and religion. So this is related to right to religion. Then there is article number 26, which provides freedom to manage religious affairs. Freedom to manage religious affair. Then article 27 deals with freedom to pay taxes for the promotion of any particular religion. Here managerial rights is there. And finally, the last right to religion is 28, which gives freedom to attend from religious instruction in any educational institutions. So these are the different kinds of rights under freedom of religion. Now we'll move to another type of fundamental right, that is cultural and educational right. So Article 29 is a fundamental right related to protection of language culture of minorities. Then Article 30 is related to right of minorities to establish educational institutions. And finally, the last fundamental right is right to constitutional remedies. This right provides all the citizen right to move courts, and court will issue directions, orders and writs for the enforcement of the fundamental rights. And the last right is right to property. But at present, this right has been deleted and it is inserted from fundamental rights to Article 300A. So earlier it was fundamental right, but now since it is outside Part 3 but in Constitution, it is called as constitutional right. It is called as constitutional right and not fundamental right because it is outside Part 3 but in the Constitution. So right to property was earlier fundamental right, but now right to property is a constitutional right. Then we'll see now, after having classified fundamental rights into different types, we will see each right in detail. So right to equality. Why this right to equality is important? This right to equality prohibits discrimination. It provides equal access in places like shops, hotels, palaces, wells, bathing guards, etc. Also, it prohibits discrimination on grounds only of RRCSP, religion, caste, sex and place of birth. It also prohibits discrimination in public employment. This right is very important because our society did not practice equal access due to caste system. Then you have seen that article number 17 or under article 17 there is a prohibition of untouchability. This is also one of the crudest manifestation of inequality. So right to equality has abolished untouchability. The same right avoids titles. Okay, so this is how we have deal with this all articles. Then there is an article 16 clause 4. It is related to reservation. It enables state to provide a reservation in favor of backward classes of citizens in the opinion of state is not adequately represented in the services. So article 16 clause 4 is related to reservation and it enables state to make laws related to reservation. Now, having seen all these rights, we will see that there is another right, equality of opportunity. This right is given under Article 16, equality of opportunity. Equality of opportunity means all sections in the society will have equal opportunities. But in society where there are social inequalities, what do you mean by equal opportunity? So when there are social inequalities, what constitution will do? Constitution will implement special schemes and measures so that those sections of society, children, women, socially and educational backward classes, can have equal opportunities. And it is done through the reservation in jobs and admissions in the educational institutions. This is specifically done by Article 16(4), which explicitly clarifies that the policy of reservation will not violate right to equality. So, reservation by providing equal opportunity to the disadvantaged sections of the society creates equality in the society. It is for this reason reservation is not seen as right to violation of right to equality, because rather than creating inequality, reservation creates equality. So this reservation is required for right to equality of opportunity, to create right to equality of opportunity. So in a society, if you want to create right to equality of opportunity, there should be reservation. It is through reservation you can have equality of opportunity in the society. After seeing this right to equality, now we'll move to Article 21 or right to freedom. Right to freedom is included in Article 19, Article 20, 21, 21 capital A and 22. Right to freedom. In this there is another Article 21 which is related to protection of life and personal liberty. It says no person shall be deprived of life or personal liberty except according to the procedure established by law. This will deal in detail ahead in this chapter. So in this topic, right to freedom, we will see that equality and freedom of liberty are two rights which are most essential for the democracy, and you cannot have freedom without equality or equality without freedom. So it is not impossible to think one without thinking of the another. So by liberty, what do you mean by liberty? Liberty means freedom of thought and expression. However, it does not mean freedom to do anything as one desires. So this is what freedom means. Now we'll see right to life and personal liberty. It has been granted under Article 21. Right to life and personal liberty. Here, no citizen can be denied his or her life except by the procedure established by law. No one also can be denied his personal liberty. So what is the meaning of this? That no person can be arrested without being told the grounds on for which he has been arrested. And since if he has been arrested, he shall have right to be defended by his lawyer. And it is also mandatory for the police to take person to the magistrate within 24 hours. The magistrate, which is not a part of police, will decide whether the detention or arrest is justified or not. And if it is not justified, the person will be set free. So, this right to life and personal liberty, it is not just confined to person's individual life, but it has a wider application. And various judgments of Supreme Court have expanded the scope of this right. Which right? Article 21. In what manner? We'll see ahead. How Supreme Court has expanded this life in the broadest possible manner. So, this right to life under Article 21 also includes right to live with human dignity, free from exploitation, right to shelter and livelihood. So, all these are necessary for right to life. Now, we'll see the concept of preventive detention. What is preventive detention and how Constitution of India protects an ordinary citizen from preventive detention powers or law when it is misused. So you will see that ordinarily when a person is arrested, he or he is arrested after the commencement when the person has committed the offense. But sometimes a person is arrested just or because he has been apprehended that he is going to do some crime, and before doing some offense he is imprisoned, and that too without following the above procedures. So this kind of detention before committing any crime and without any procedure, it is called preventive detention. So this is the meaning of preventive detention. So what is preventive detention? That if government thinks that this person is a threat to law and order or peace or security of the nation, this kind of person can be arrested or detained. And this detention can extend for 3 months, and beyond 3 months also it can be extended if it is approved by advisory board. So on one hand, you can see that this tool of preventive detention is very effective in the hands of government to deal with antisocial elements, but it has been also seen that this provision has been misused by the government to suppress the criticism. So we need greater safeguards against its misuse and prevent its misuse. In fact, a clear tension is between right to life and personal liberty in the provision of preventive detention law. So there is conflict between two. If you have preventive detention law, it will violate right to life and personal liberty. If you have right to life and personal liberty, then this preventive detention law cannot be there. Now we'll see the other types of freedoms or other types of fundamental right. One of is right to freedom of speech and expression, but this right is subject to restriction that it should not violate public order, peace or morality. Also freedom to assemble is peacefully and without arms. So government can impose reasonable restrictions on this. But these powers are generally misused by the administration. A genuine protest against the government can also be denied on the grounds that it violates public order, peace, and morality. Now, having seen this kind of rights, now we'll see rights of accused or the person who is facing conviction. These rights are under Article 20. So, whenever a person is accused of any kind of offense, he'll stand a trial and he won't be given punishment unless he is proved guilty. So, until and unless he has been proved guilty, this person has three kinds of right. So what are these three kind of rights? First is no person should be punished for the same offense more than once. This is called as no double jeopardy. It means if a person has committed crime, for example, if A has committed some murder, in this case, A has been given a punishment of 10 years. So after completing 10 years, he again cannot be given punishment of 10 years because he cannot be punished for the same crime twice or more than once. This is called as double jeopardy. This is granted under Article 20. Then the another right is no law shall declare any action as illegal from the backdate. It says no ex post facto law. It means a person can be punished only for the violation of the law in force. You can't enact a law and enforce it from backdate and punish the individual in the present. Then you will see that no person shall be asked to give evidence against himself or herself. It means no self incrimination. It means if A has done a murder, a police cannot take the statement of A and make A witness of his own crime and provide the evidence in the court and convict the A. Okay, so these are the three different rights under Article 20. 1. No double jeopardy. 2. No ex post facto law. 3. No person shall be asked to give evidence against himself or herself. That is, no self-incrimination. These are the three different rights under Article 20. Now we'll see rights against exploitation. So, in this topic, right against exploitation, there are two articles which are important. Article number 23 and article number 24. You can see this picture. Can you think which kind of fundamental rights has been violated? This child is employed in some hazardous work. So here article 24 is violated, which prohibits child labor. Which prohibits child labor. Now we will see that in our country there are people who are underprivileged and deprived, and they are exploited. And one such form of exploitation is begar and forced labor, that is work without the payment. And another form of exploitation is buying and selling of human beings. This is called trafficking. This both begar and trafficking is prohibited under Article 23 of the Constitution. Okay, so you can see the examples of forced labor when erstwhile landlords, money lenders who used to practice it. It is also practiced in some bricklaying work. It is declared a crime and it is punishable since it is prohibited by the Constitution under Article 23. Now we'll see Article 24. We have seen the picture earlier that the child who was employed in the hazardous work. So Article 24 under the Constitution prohibits child employment, and here the definition of the children is any person who is below the age of 14 years in dangerous job. So keep this in mind. Total ban is not in the Constitution on the child labor. So child labor in non-hazardous areas is not banned by the Constitution. It is banned only in hazardous employment. This is banned. This is allowed by the Constitution. So if someone will ask you, is total child labor banned in India? No. Under Article 24, a person who is under the age of 14 will be considered child, and he will be prohibited to work only in hazardous area. Such a person can work in non-hazardous areas also. Now we'll see the another important right to religion. According to our constitution, everyone has right to follow the religion of his or her choice. So this kind of right is called freedom of conscience. This means any person can choose any religion, or he may choose not to follow any religion also. And this right to religion also include right to profess, follow and propagate any religion. But this right to profess, follow and propagate religion is not unlimited. It is subject to certain restrictions. So what are these restrictions? Is that in the name of freedom of religion, one can propagate its own religion by persuading the people, but it cannot include forced conversion. Only voluntary conversion is allowed under this right, but forced conversion is not allowed under the constitution. So if a person converts from one religion to another, if it is voluntarily, it is allowed by the constitution, but if it is not voluntarily, then it is not allowed by the constitution, because constitution does not allow forcible conversion of any person. We'll also see that our constitution gives equal emphasis to all the religion. So India does not have any official religion of its own. For example, Indonesia has one particular official religion, that is Islam. Erstwhile Nepal has one official religion, Hinduism. But India does not have one particular religion as the official religion. So this is all about right to religion. Now we'll see another right, that is cultural and educational right related to minority. Now India is not made up of a monolithic society. Monolithic society means one religion, one culture. Our society is full of diversity, different kinds of religion, language, and it is for this reason our constitution believes that diversity is our strength. And one of the fundamental rights is right of minorities to maintain their culture. This is very important fundamental right. So these cultural and educational rights are under Article 29 and 30. So two articles are there in this right. We'll see in detail that minorities are of two types, of language and culture. So if these minorities are there, they have fundamental right to protect and conserve their culture, language and script. This right is under Article 29, and also these minorities can set up their own educational institutions. This is under Article 30 of the Constitutions. And it also imposes a duty on the government that while giving aids, it shall not discriminate on the educational institutions that they are managed by the minority community. So these are the cultural and educational rights under Article 29 and 30 to minorities, that is linguistic minorities and cultural minorities, by the Constitution of India. Finally, we'll see the last fundamental right, that is right to constitutional remedy under Article 32. This is the most important fundamental right of all the fundamental rights, and why it is important we'll see now. So what do you mean by right to constitutional remedies? According to Ambedkar, these rights are heart and soul of the Constitution. Why? Because this right gives a citizen to approach directly to High Court or Supreme Court whenever there is violation of any of their fundamental rights. And in return, Supreme Court and High Court can issue directives or writs for the enforcement of the fundamental rights. That's why right to constitutional remedies is the most important fundamental right. Now, writs. Writs are of total 5 types. There is also a sixth type of writ, injunction. This injunction is not mentioned in the Constitution. This kind of question will come in PT. There are only 5 types of writs: habeas corpus, mandamus, prohibition, quo warranto, and certiorari. So first writ is habeas corpus. Habeas corpus, in this writ, court will order that the arrested person should be presented before itself, and the court will check the legality of the arrest, and if it is found not legal, the person will be set free. In the writ of mandamus, court will issue an order to the office holder to perform the legal duty for which he is in the post. Now, in the writ of prohibition, here higher court will issue a writ on the lower court in case if it is exceeding its jurisdiction. In case of quo warranto, here court will issue a writ to the person who is holding a public office, whether he is holding the public office legally or he has usurped the public office. And finally, the writ of certiorari, here a court or a higher court will order on the lower court to transfer the matter pending before it or squash the order in case if the lower court has exceeded its jurisdiction. So apart from judiciary, you have other bodies like National Commission on Minorities, National Commission on Women, National Commission on Scheduled Caste and Scheduled Tribes to protect fundamental rights. So here we have completed Article 32. Here you will see that there is an institution called National Human Rights Commission to protect the human rights in India. It is composed of former Chief Justice of Supreme Court, former Judge of Supreme Court, former Chief Justice of High Court, and 2 other members. So these are the functions of the National Human Rights Commission, that it will do inquiry in case there is a violation of fundamental rights. Every year this National Human Rights Commission receives thousands of complaints related to custodial death, custodial rape, disappearances, police, etc. And this commission but does not have the power to prosecution. It can only recommend to the government or court to initiate the proceedings or inquiry that it conducts. Now, having seen this, we'll deal with directive principles of state policy.